Hi, thank you so much for the introduction. I'm going to be talking about management agreements today. We've seen, these being used in the cannabis space for quite a long time now. The purpose of the management agreement has changed over time, but I'm going to be speaking mostly since I practice in California. Most of this is with California law in mind, but I'm sure, it can apply almost anywhere. Um, if we could go to the next slide. So, so a management service agreement, which is often referred to as an MSA, those come in all shapes and sizes, but the issues that need to be focused on by the parties pretty much remain the same. Can we go to the next slide? Okay, so you always want the normal contract terms, which are termination standards, material breaches, waiver, assignment, indemnification disputes. The term, how long are you going to be in the agreement for? Is it a 1-year contract? Is it a 2-year contract? Is it a 10-year contract? That's obviously going to be negotiated and mutually acceptable to the parties. Termination standards. This is something that is sometimes overlooked. You want to think about and really think about, what are the termination standards here? Do you want, 30-day notice, 60-day notice, 90-day notice? Can you terminate at any time? Or is it only after the term of the contract has run its course? And the types of considerations here are going to be, what constitutes cause for termination. So can it be for any reason, or is it for breach, and what kind of breach? And that brings you to material breach. What is a material breach? It's something that substantively affects the ability of the parties to honor the agreement. And so, the obvious ones there are failure to pay, any fees owed, or compliance related issues, anything that is kind of like a morality break. So like a fraudulent, or some sort of breakdown in the relationship, whatever that may be. Now, it really also depends on the nature of the management agreement. Are you a licensed business that's contracting with the management agreement so they can come and run your operation? That's kind of what we're seeing more than not be the case. And there's also certain compliance reasons for that relationship. One company has a license, the other company doesn't. One company might have operational know-how while the other needs help there. And so that's why they hire the management agreement. So that's kind of usually what the relationship looks like, and that's going to help guide your termination standards, and what constitutes a material breach. Waiver, assignment, indemnification, those are kind of standard legal aspects of any contract. So you obviously want those included in there. But really the breach and the termination standards are the ones that you're going to need to be the most thoughtful about. Think about, I always say to my clients, every divorce started with marriage, right? So that means that at some point everybody loved each other, and now we're ready to break up. So let's imagine a world where we broke up, and what happened there? What caused the breakup? And let's work backwards from there. That's kind of, I always, like to assume the worst and hope for the best. So those are your normal contract terms, and we can go into a little bit more kind of like management specific considerations on the next slide. So the scope of services, this is obviously huge. Are they going to be handling your administrative services, your payroll? Are they going to be managing your employees? Are they going to actually be supervising the production if you're a manufacturer or a cultivator? There's specific responsibilities for that. So you want to be really, really mindful about what specifically they're supposed to be doing for the company. So you have the company and the manager. And so we need to figure out what that relationship is. Sometimes the manager has a very small role, and sometimes the manager has a very large role. It just depends. And so that's something that you really want to think about and be detailed about as well. What I like to do is I like to walk through with my clients, the production line. If my client is the company, let's walk through the production line. What happens step by step, and how much of this do you want the manager to be overseeing? And that kind of helps to kind of, iron things out. Same goes for control and authority. So, some companies like to maintain a large amount of control. Maybe, their brand and their product is really specific. So they don't want the manager kind of compromising that or doing anything with that. Maybe they just want the manager doing more administrative type stuff. So that's something you really need to talk about. And also authority, which means, what can they do on behalf of the company? Can they enter into contracts on behalf of the company? If so, up to what, dollar amount, or what kind of contracts can they enter into? Can they do sales on behalf of the company? All those kinds of things are things that you want to iron out beforehand. And then I always like to kind of create a clause that says something to the effect of, these are the types of matters or agreements that the manager does not have authority to conduct and must get consent from the company. Because when you think about it that way, it's like, okay, what are the things that are most important to the company to maintain control over? So that's kind of the way that I guide that discussion with my clients. Compensation, that's obviously an important one. How is the manager going to be compensated? And this varies greatly in the cannabis industry. Sometimes it's just a percentage off of revenue, gross revenue. Sometimes it's a percentage off of net revenue, and sometimes it's a flat fee. The concern with percentage off of net is that the definition of net becomes very important and can become the subject of debate later on down the road. What was actually included, what actually wasn't included. I think the preference is to go with gross, just to make it clear. But obviously, the company is going to prefer net. And flat fee is just kind of clean and simple, but sometimes doesn't always have all the bells and whistles that you need in this kind of agreement. So it really depends. Sometimes it's even like a hybrid of the two. I've seen flat fee plus percentage, depending on, what kind of services are being rendered, especially in situations where it's a distributor license. So it just depends. And then if you are going to do percentage of net, accounting obviously becomes very important, and audit rights become very important. So that's something that, needs to be kept in mind. And if the manager is the one actually doing the accounting, then the company has to have some sort of oversight or audits. You can also get a third-party controller or someone like Rachel in there to really set you up and do it right. Employees, this is one that is often just kind of seems to cause a lot of discussion and back and forth. Sometimes the manager wants to bring in their own employees, or the company wants their own employees. So you have to really hammer that out neatly. Sometimes a manager can lease out their own employees to the company. And that's something that we see done often. And so the employees don't actually have to become employees of the company. From a compliance perspective, that works. And sometimes from an accounting perspective, that works as well. Really depends on who I'm representing and what I would advise. But, the world is your oyster when it comes to negotiating that kind of stuff. Regulatory disclosures, that is a huge one. Sometimes the manager, depending on their role, has to be disclosed as either a financial interest holder or an owner in California. It just depends. And so I like to include in the contract that the manager agrees to be disclosed to the extent necessary from a licensing perspective. Regulatory changes, the regulations are changing so often that that's something that you need to allow for in the contract. I think I go into more detail in each of the slides. Let's go to the next slide. Yeah, so the scope of services can be specifically set out or defined broadly as providing advice or assistance in the management or day-to-day operations of the company, whatever is adopted. The MSA needs to be sufficiently flexible to account for the wide range of services that we provide for the manager. So all services reasonably necessary or desirable for the operation of the business is one of these kind of blanket languages that you can throw in there. So that's scope of services. Next, let's go again into control and authority. Next slide. Like I touched on before, it's the manager's role, responsibility, and discretion. Sometimes they need to negotiate contracts and enter into commercial discussions. The management services agreement should make clear that the manager cannot bind the company to any material contracts without the company's express approval. And we kind of discussed that a little bit. This will give the company comfort that is being kept informed of everything that's going on. And for the manager, it also provides protection so that if the deal later fails, it's hard for the company to blame the manager if the company itself approved the deal. So what makes a contract rise to the level of material is different for everyone, but typically a company will want to define what a material contract is. And it's, like I said before, it's a predetermined dollar amount or outside the normal course of business, or any contract that obligates the company to add a financial interest holder or an additional owner to the license. Let's go to the next slide. Compensation, this we talked about as well. It's negotiable, obviously. There's no standard here. Some managers are compensated for a set fee, some is a percentage. So it's something that's negotiable. Fairness is fundamental here. We go to the next slide, employees. So we talked about this a bit. Managers, employees are often used, and it can create confusion as to who is the legal employer. And this is what we talked about, professional employment organizations, PEOs. That's where I was saying that, it's the manager's employees that are leased to the company. So that can help. In this arrangement, the employees will not be considered the company employees. So they'll receive their W-2s and other employment benefits from the manager. So the manager is solely responsible for compliance costs, payroll, employment taxes, workman's comp, and medical benefits. This approach better protects the company from being held liable for employment lawsuits filed by employees that are provided by the manager. Next slide. Accounting and audit rights. This is something we talked about as well, and this is the best way to combat the risk of fraud between the parties, especially when the manager's compensation is based on revenue. And this kind of helps build the trust between the parties as well, and I've included some sample language for you in there that's kind of helpful. And then additional provisions for audit findings and costs is sometimes advisable. So if if the company requests the audit and the audit is the company's costs, but the company ends up finding that they're owed money, then the manager would be responsible for the audit costs. So that can be kind of like a nuanced kind of small little detail to include to make sure that everything's fair. We can move to the next slide, please. Regulatory disclosures in California. This is very important. Sometimes they have to submit to a live scan. And an interesting thing to note is that if the manager is actually an entity, like a corporation or an LLC, all individuals associated with that entity will need to be disclosed. So it's down to every single individual. The entity itself is not enough. And if the disclosures aren't timely made, the company could be in major trouble. So you want to make sure that the MSA explicitly addresses obligations around disclosures. And regulatory changes. So our final slide, cannabis laws are constantly evolving and the MSA must be flexible to allow for that because the MSA will likely be affected by these changes. So you always want to reserve the right to amend the MSA in light of any changes and make sure that the MSA doesn't bind hands or unknowingly drain profits. Since MSAs have long lived in the cannabis industry as a workaround to restrictions and legislation and regulation, all the way back from the nonprofit days to license caps in LA, for example, they've drastically evolved in purpose and implementation. But you want to make sure that your MSA works to your benefit and doesn't bind your hands. And of course, the attorneys here at Manzuri Law can help draft and negotiate these on your behalf. That's all I have for my slides and happy to answer any questions.